We apply the facts to the law in every single case that we do, and we make our best judgments as to whether the facts sustain the evidentiary burden, an admittedly high evidentiary burden that we have under Section 11B. We do that analysis in every case that we bring, in every statutory context in which we bring a case. We apply the facts to the law and make our best judgment possible, and that's what was happened in this case. Again, this is not the first, and nor will I will predict with great confidence will it be the last case where, as you move up the chain, you have robust debate and differences of opinion about how to apply a set of facts that we have before us to the law that we must apply.
And one last question. If, in fact, you determine that default was not appropriate for at least two of the defendants and only a narrow injunction for one of them, why not make that determination or yield that determination to the trier of fact?
I yield 2 minutes of my time so you can finish the question.
This was the judgment that was made by the two people with 60 years of experience, and they looked at the entire totality of the circumstances. They reviewed all the evidence that they had before them, and they made their best judgment on the merits. And again, this is we will continue to have cases in the Department of Justice where we move up the chain and we have robust dialogue and debate. We can always, after the fact, say, could you do this, could you do that? They made a decision on the merits based on the evidence that was presented before them at the time, and it was a decision that was made by the Acting Assistant Attorney General, and it was the product of, I think, very careful consideration. Are there people who might disagree with it? Undeniably, or we wouldn't be here today. But we will frequently have decisions that we make that people will disagree with, and that's the beauty of representative democracy, is that people can indeed disagree.
Thank you, Mr. Perez. Thank you, Mr. Chairman.
Okay. Well, Assistant Attorney General Perez, thank you for your time.
Thank you.
I suspect that you'll be hearing from us again. We would appreciate the opportunity to seek out ways that we can get information that will help us inform our final product, our report, but get it in a way that we don't undermine the work that you do. I think that if we have good faith discussions and negotiations over some of the remaining discovery disputes, I suspect that we could reduce the size of the dispute. But in any event, I thank you for providing us with the time you did. This is an interesting case.
Thank you. And we'll continue to keep the lines of communication open.
All right.
Thanks from all of us at
Thank
the
you.
Commission.
Have a nice day.
Okay, folks, at this time, closing statements for the commissioners who wish to make them. Vice Chair Thernstrom, we'll start with you.
Oh, I had a closing question for him, but I'm not sure I have a closing statement. I guess I'll say two things. One, I very much appreciate Mr. Perez coming today. I thought he answered the questions forthrightly and with integrity. I cannot say too strongly that I agree with Attorney General Meese that an administration cannot function if its internal deliberations are always vulnerable to ending up in the public sphere. And lastly, as I understand it, there is no evidence that the new Black Panther Party, which is a lunatic fringe group and dysfunctional lunatic fringe group, largely dysfunctional, was sufficiently well organized to show up at any other polling place and to be likely to show up in a suburban setting or other urban setting. And thus I appreciated his stress on the fact that, look, different attorneys can look at the same facts and come to different conclusions. This is a legitimate argument between people of integrity, both on this commission and in the Justice Department. And I think we need to respect both sides of this dispute. That's it.
Commissioner Graziano?
I think that there are two, what comes to mind about the conflicts that we have with the department's refusal to cooperate come down to this. Greg Katsas testified very clearly and very explicitly that a decision to dismiss a lawsuit could not have been made at the division level alone. And we have some interrogatory answers from the department that suggest Pirelli was consulted. I think we need more clarity on exactly what the role of Pirelli, Holder, and others were, because we heard time and time again from the Assistant Attorney General that the real decision was made at the division level. We have a former Associate Attorney General who said that is impossible. Secondly, notwithstanding the 4,000 pages of largely peripheral, redacted documents the department has given us, we all know the elephant in the room. They won't give us the most important and helpful material that would help us in our investigation, and that is interviewing 4 to 6 people who would help us understand whether an impermissible racial motive or other impermissible motive was at play. Those individuals include Pirelli, King, Rosenbaum, and some of the trial team. There might be 1 or 2 others if we were allowed to do our job back in October and begin where we are. But the central question is, why do they continue to stonewall in allowing us to do our job and interview, depose, or hear testimony from those critical witnesses? And why won't they even appoint a special counsel to allow us to take that legal issue to court?
Commissioner Yaki?
Thank you very much, Mr. Chairman. As I think I've made it very clear, I think that we're spending an enormous time and resources on relitigating an issue, a single-focused issue, and trying to bootstrap within it some Whitewater-esque conspiracy, which I think is going to get us nowhere and only undermines our credibility as a commission. We somehow are going to create this atmosphere that the Justice Department will not be pursuing enforcement of voting rights. And I would just like to say this. When you look at what happened during the Bush administration, when you look at the fact that they declined people wearing guns intimidating Latino voters, that they declined people interviewing elderly black voters in their homes in Mississippi, interviewing elderly Latino voters in New Mexico, going into Philadelphia with in sort of a Men in Black type outfits, and this commission has turned a blind eye to that for years, turned a blind eye to Katrina, turned a blind eye to so many other issues. But somehow, in this particular instance, we're going to find fault with the Justice Department is the height of hypocrisy. I agree, with Commissioner Thernstrom, we should try to be respectful, but this process has shown no respect for process, has shown no respect for fairness, and once again, I just think that this is a laughable exercise of the Commission's powers.
Commissioner Melendez?
I didn't have a statement. Thank you.
Commissioner Harriet?
Well, I had thought I wouldn't make a statement, but I guess I'm going to go back to my plan to make a statement here, and that was just that to make, I think, what is one single point, and that is in the year running up to the 2008 election, there was a lot of very partisan bickering about election procedures. Republicans argued on the one hand that there was a lot of voter fraud out there in the world. Democrats argued that there was a lot of voter intimidation out there, and that something ought to be done. And in truth, I have to tell you that I thought that both sides were overstating their case, although, of course, voter intimidation and voter fraud are both very important issues, and they need to be dealt with. It seemed to me there was more hysteria than was appropriate. But because the Bush administration was a Republican administration, naturally the accusation was that the Bush DOJ was not doing enough about voter intimidation. So I thought, perhaps naively, that when the Obama administration came in, that they would naturally want to emphasize voter intimidation, as is their right. I have no objection to that. I believe that each administration has